Hello and welcome to ET Now. I'm Ashwin Mohan and you're watching our special show, The Panama Files. Panama, a tiny nation in Latin America with a population of just around 4 million people, is now at the center of perhaps the biggest ever leak of confidential documents. 11 million offshore files have been leaked from the database of Panama-based law firm Mossack Fonseca. And the expose reveals multiple ways in which secretive tax havens have been exploited by the high and mighty for concealing income as well as laundering money. 500 Indians have been named in a global list which includes top politicians, heads of states, industrialists, entertainment bigwigs and even lawyers. The cat has been set amongst the pigeons, the blame games have begun and the government has swung into action. Before we move on, let's first hear out Finance Minister Arun Jaitley on this expose that has shaken not only India but the entire globe.
HSBC में लगभग 600 से अधिक लोगों के नाम आए थे, जिसमें 569 लोगों को ट्रेस आउट किया गया। जो गैर कानूनी पाए गए उनके खिलाफ असेसमेंट प्रोसीडिंग्स कंप्लीट हुए। लगभग 6,500 करोड़ के एसेट्स वहां पर डिस्कवर हुए और आज उसमें से 154 प्रोसिक्यूशंस पेंडिंग हैं। आज के रेवलेशंस हैं और समाचार पत्र से ये प्रतीत होता है कि अगले कुछ दिनों में कुछ और नाम स्पष्ट होंगे। तो जितनी भी डिटेल्स आएंगी जिन नामों के संबंध में, आज वित्त मंत्रालय ने एक मल्टी एजेंसी ग्रुप जिसमें सीबीडीटी, सीआईयू, एफआईयू और आरबीआई ऐसे कई संस्थाओं के जिसका वित्त मंत्रालय से संबंध है और इस विषय से संबंध है, उस मल्टी एजेंसी ग्रुप को बनाया है जो इसको कंटिन्यूअसली मॉनिटर करेगी। माननीय प्रधानमंत्री जी ने स्वयं इसका आग्रह किया है कि इस पे पूर्ण रूप से सरकार कार्रवाई करे।
And to throw more light on the ripple effects of this Big Bang expose, we are joined by the who's who from the world of tax, Dinesh Khanabar, CEO at Dhruva Advisors, Rohan Shah, Managing Partner at law firm ELP, and Mr. B.M. Singh, former chairperson of the CBDT or the Central Board of Direct Taxes. Gentlemen, thank you so much for taking out time and joining me on the show. Mr. Singh, let's kickstart with your viewpoint as far as this entire expose is concerned. What do you make of the timing of this expose? Because it comes at a time when the government is already in the middle of prosecution against several individuals, and assessment has of course taken place against them by the Income Tax Department, and I'm referring to the earlier HSBC list. So now suddenly this fresh big list pops up. Do you think there's bound to be an overlap, and also will this fresh list put extra pressure on the government to act against the entities that have been named?
Yes, of course. It's a hot topic right now that lots of number of people have got their black money, so-called black money, stored abroad in various funds, in various bank accounts, in various jurisdictions. But whether it was timed to match the earlier investigations, I'm doubtful. It's an expose, and Indians are only a small part of this expose. I believe there are millions of files, and they relate to many, many more important people than in India. I believe there are several heads of states which are mentioned or linked to these exposes. So, and it's a leaked information which has been obtained by a German entity from an anonymous source, and then further it has it has been exposed, it has come out in the press, but I think a lot of work is required. It's like an onion which has to be peeled layer by layer, and you'll find beneficiaries and holding companies and others, and ultimately it may take months before the actual beneficiaries, the actual information comes on record as to what is required to be done or what can be done by the government under our present tax laws.
Mr. Singh, you raised a very important point. It's definitely going to be a mammoth exercise, and that's where I want to bring in Dinesh Kanabar. Dinesh, 500 Indians named in the list. Clearly, as Mr. Singh was pointing out, India is just a part of the global pie, but 500 Indians, many prominent ones being named. What do you make of the timing of this expose? And also, clearly it's going to put extra pressure on the government, who of course came to power, in fact, very confident that it would shed the tag of tax terrorism.
So, Ashwin, the way I see it is that we first had a situation where there have been varying estimates as to what is the amount of Indian black money which is stored overseas. There have been various numbers floating around. The most official number that I've heard from government source is close to $500 billion. And the government came out with a scheme last year, the Black Money Act, to say that if people have assets overseas, can they please declare it, and they would have to pay a 30% tax and a 30% penalty, and that would be the end of the matter. The declarations under those schemes were pretty pathetic. The government collected somewhere between 2,400 and 3,700 crores. There are various numbers which one has heard. 2,400 seems to be the more authentic number. And that obviously was a tip of the iceberg which was sitting out there. It was very surprising. That was only just a small number which came to the fore. Coming to the present thing, really, the fact of the matter is that there are documents which are out in the public domain. And as you rightly said, there are really different types of people who would be covered by this. As I read in the newspapers this morning, to my mind, there were three distinct categories of people which came in. The first category is the people who are non-resident Indians, who are based overseas. They may have relatives in India, they may be part of an industrial family or a group, but they are non-residents and they have got assets overseas. That's one category. The second category of people is people who are resident Indians and who have officially remitted monies overseas under LRS scheme. And those people who have sent out those monies have got monies officially. They were bound to, and they ought to have declared those monies in their tax returns. And then we have third, monies which are lying overseas, which are unaccounted and therefore covered by the Black Money Act. As you know, what is provided in the Black Money Act is that if a declaration is not made under the Act and thereafter anything else is found, then you are liable to imprisonment for a minimum of 3 to a maximum of 7 years, and you are also liable to a fine. Those are the last category is the group
on that
of people.
point, I in fact want to raise this aspect about whether this information can in fact be used as evidence. What's really the sanctity of this information that has now been exposed to the entire globe? And that's where I want to get in a legal viewpoint. Rohan Shah of ELP. Rohan, what do you make of the sanctity of this information? Can it actually be used by the income tax authorities to proceed against the Indians named in the list? You heard Mr. Kanabar speaking about the various stakeholders that are likely to be impacted.
Look, to my mind, one of the things you have here is that this information, now that it is out in the public domain and has come through the media, the one big risk you have from a legal perspective is that you're going to try and tar everybody with the same brush. And the fact is that each of these cases is going to be distinct based on its own facts. And, people who have a legitimate source from India, for example, have gone out through the LRS, etc. You might find that their facts and their position in law is completely distinct from several others. But today the tendency is that, we will in first flush tend to say there is something wrong, and I think that is completely uncalled for. And the reason for that is the point that you were making in terms of the sanctity and admissibility of evidence. Whether this is stolen information or not, or whether it is information illegally procured, the source of that information itself will in a way determine what is going to be the admissibility of this. Then, depending upon the detailing and whether the documents in question come from a legitimate source, whether Panama or BVI effectively sanctifies these as saying, yes, these have been procured and endorses that. Thereafter, you're going to go into another situation, admissibility under the Evidence Act, admissibility in the context of the Income Tax Act and the other acts. So to my mind, right now what we're going to do is try and probably herd everybody together, which would be completely unfair because the facts are different. Second, I don't think we can at this stage opine on the admissibility of evidence, but if you've seen this in the past, this is not going to be automatically admissible. It will have to go through first the process of sanctifying the source and then whether it meets the yardsticks of our Evidence Act or not. And even if you have a document, you will have to see whether it indicates an illegality. The fact that you have a document for a foreign source is not a presumption of illegality.
All right, Rohan, and that's an important point that you raised over there. And there is clearly a risk of putting perhaps the guilty and the non-guilty parties in the same bucket. And that's where I want to bring in Mr. Singh over here. Mr. Singh, the big question now is, how does one differentiate between the legitimate offshore structures and the illegitimate offshore structures? Because let's be clear over here, having an offshore structure overseas is entirely legal. It all depends upon the end user proceeds. So how do you think, how difficult do you think it will be to sift for the government when it comes to identifying what's legal and what's illegal?
As I said earlier, it's be a long and labored process to sift this information. Firstly, as our friend Rohan Shah has pointed out, the admissibility of the evidence will have to be seen, whether it is sanctified by the concerned authorities under the treaties, and then we'll have to go through the information which we receive. And as far as what I was reading was that there are intermediaries which have set up these accounts, and as far as this law firm is concerned, they said they have particularly done the due diligence before they open these entities or these structures. And what would come in front now, what will be questioned is the intermediaries. Now, where these intermediaries reside and what information we can get regarding these intermediaries will also depend on what kind of treaties we have with these various countries. Besides the Income Tax Act getting information to exchange of information, there is a treaty regarding, there is a mutual legal assistance treaties regarding prosecution of these people and whether we can put them under those treaties. Now, all this requires a lot of time, manpower and hours of labor. I don't think it's going to be done in a hurry. I think we may see months, if not a couple of years, before any fruitful action can be taken against them. It's not something which comes off.
So clearly, in fact, Mossack Fonseca is not going to be the only firm under the radar, because in their official statement they have pointed out that they cannot be held responsible for the lapses of several intermediaries like perhaps the accountants, the lawyers and the banks. Mr. Kanabar, we have to slip into a short break, but if you could summarize for us, what is going to be the biggest challenge for the government authorities to distinguish between the legitimate structures and the illegitimate structures as far as probing this entire case is concerned?
So before we go to the government, I would actually come back to the media, that we should not have a trial by the media in absentia. And in fact, this morning, as I was reading up, I went to the ICIJ website. The website actually goes on to say that the very fact that there are names of people appearing on our website is not indicative of the fact that these people have violated any law. So first and foremost, if there are people who, for example, have sent monies legitimately overseas under LRS, have declared these monies in their bank statements, there is no need really to undergo into a sort of a witch hunting and a media trial. And that's something which we need to be very, very sure that we are avoiding, because we could irreparably harm the image up. So as I was reading, for example, the newspaper report was very, very evident that there were several people, including those from the legal profession, who had very categorically made averments to say they have sent monies overseas under LRS scheme which is permitted in law, and therefore the monies are legitimate. We should not really paint everybody in the same brush and have a media trial. On the other hand, I read certain names for which it would appear that people have sort of amassed huge funds overseas, and those which need to be legitimately really investigated. You know, I was hearing this whole conversation as to admissibility of the evidence, and sometimes we tend to look at this whole thing from a purely legal framework. There are two frameworks to it. One is really the government will do an investigation, and having had this information, it will allow them to gather a lot more information. So it's not merely admissibility of this information, but what it will lead to. And number two, how do we really shift the people who are not at all guilty from others and sort of get them out of the media glare and give them a clean chit?
This is going to be the million-dollar question, and that of course will also be the biggest challenge for the enforcement authorities as far as unraveling this entire complicated probe is concerned. On that note, we'll have to slip into a short break. Stay tuned and keep watching the Panama Files, because on the other side, we're going to talk about the discretionary powers of the Income Tax Department, the tax treaties that come into focus because of this expose, and much more. Stay tuned to ET Now. Welcome back to our special show, the Panama Files. And now, Rohan, I would like to ask you, in February 2011, the government had announced that it had entered into a pact with British Virgin Islands. And this pact, of course, was for exchange of information to counter money laundering and also to, in fact, check tax evasion. Now, the British Virgin Islands is, in fact, the offshore jurisdiction at the center of this controversy. Now, I've spoken to a few people offline on this particular expose, and they tell me that any investment made after 2011 or even before would be disclosed. So they fear that perhaps what is happening is that Panama and the British Virgin Islands are getting mixed up. Do you concur, Rohan?
I do. Because quite clearly, now that we do have, as you mentioned, the 2011 treaty, quite clearly BVI is going to exchange information, is obligated to. So when you look at BVI and Panama, you are really talking of two separate propositions altogether, because in one there is a legitimate channel which ensures the flow of information, and therefore whoever effectively goes in there goes on the expectation that what they are doing there is going to be disclosed. Panama, to the extent that we don't have such a treaty or such a set of provisions, although I am told Panama has said that they will cooperate and exchange information, but to the extent that we don't have that, I think it would be wrong to mix up, BVI with Panama. Just as, has been mentioned in this program, we need to be very, very careful in terms of, how we sort of look at everyone here. The sense is we will, in our minds, indict every one of these people, but several of them have a very legitimate basis, which even the media has reported. But, we haven't sifted through this. We've treated everyone the same. So hopefully those who've operated in BVI will also get a certain sort of a consideration given the treaty that you mentioned.
Rohan, correct me if I'm wrong. So in the absence of a treaty with Panama in terms of tax exchange information, can the Indian income tax authorities even approach Panama for information relating to the entities named in this list? Is there any accountability, or we all have to depend on the generosity of Panama, as you spoke earlier, that they are in fact willing to cooperate?
I don't think there is, a medium or a mechanism by which you can sort of force them. But given that the spotlight now is on Panama, given that they were making their way to a certain form of credibility, I think they may very well take the step forward in terms of cooperating. So while I don't think you can sort of force them, if they do make the information available, if they do sanctify the source, then, we at least have the information to begin with, and then the process of law will effectively take over in terms of the secondary or tertiary evidence that you need.
All right, Rohan, point taken. Now, Mr. Singh, it seems to be pretty clear over here that on one hand, you do have the British Virgin Islands, with which we do have, in fact, a pact that has been entered into. And on the other hand, we don't have any sort of proper pact with Panama. So how do you read this entire confusion between the British Virgin Islands and Panama, Mr. Singh? And how do you think this will impact the entire probe going ahead?
I think Rohan has answered this question quite well earlier. But the point is, one point I want to emphasize is that this is just one particular law firm which is helping people to set up various entities in various jurisdictions. Offshore structures are being set up. Now, they may only be able to give you the list of beneficiaries. Now, where these beneficiaries reside, under whose jurisdiction they come, whether it's British Virgin Islands, Bahamas or others, now it will depend whether we can get the information from these other jurisdictions. As far as I know, Panama does not, the government will not be able to give you the list of the beneficiaries, but they may be able to extract the list of the intermediaries which approach this particular law firm to get to set up these structures. So there'll have to be various further investigation, getting of information from the other jurisdictions.
Do you foresee a situation as a tax advisor? Mr. Singh, I'll come back to you, but Mr. Kanambar, do you foresee a situation as a tax advisor wherein perhaps the overzealous, or at least the overzealous part of the Indian Income Tax Department, some of the authorities might be tempted to slap notices left, right and center and perhaps even conduct search and seizure operations in the interim period as far as progressing in the probe against the Indians named in the Panama list is concerned? Is the India Inc. or are the people who have been named vulnerable to that risk, Mr. Kanambar?
So theoretically, Ashwin, that risk absolutely exists. But if I just go back to the HSBC expose which had happened, that's not exactly how the tax office went about doing it. They actually did their investigation, they got the information they need to, and you know, the point which you made and what was earlier discussed about the exchange of information pack that we have with BVI is really the point I was raising earlier in a different context, Ashwin, to say that when you ask about admissibility of evidence, it is not the admissibility of this evidence. Once this evidence exists, it is incumbent on the government of India, and I would like to believe that exactly they will go about doing it, write to BVI, get the information, write to Panama, extract whatever pressure they can to get that information, and then use that information to make inquiries. And I don't think, therefore, there's going to be a random search and seizure, and that's what is my expectation, my hope, and my belief on the basis of what has happened in the past. As I mentioned earlier, what I'm worried about is that given the fact that the people whom we are talking about are very, very prominent people, their names will get tarnished simply because they are all appearing in the same list, and that is what ought not to happen.
Right, point taken, Mr. Kanambar. With that, it's time now for closing comments. And Mr. Singh, I want to refer to one major policy change, in fact, and that's a policy change relating to the RBI. Now, until 2003, Indian citizens were not allowed by the RBI to set up an overseas entity. Of course, that changed. And in 2004, the RBI allowed, in fact, resident Indians to remit funds of up to $25,000 per annum. Now, this is, of course, under the liberalized remittance scheme that has been referred to earlier during the discussion today. Today, that limit stands at 2,50,000. But I want to know, is there scope for misuse of this particular route? And do you think perhaps there are certain entities that are exploiting this route and under the garb of this route are stashing away money overseas?
Well, if it's going the normal way, the way RBI envisaged, and it's going through the banking channel, I don't know how they can misuse it, because they have to report this in the income tax return. If whatever interest or dividends are earned on the investments have to be reported in the income tax return. After all, we are taxing them on the global income if they're residents in India. And the tax treaties do come in as to where they're going to be taxed, whether in the jurisdiction where they're invested or whether in India. So what type of misuse, I don't foresee if it has gone through the regular channel. But one misuse could be that they use this money to acquire or buy shares in companies already set up and thereby take control of those companies, which are actually become a front of their control of their sort of sphere of influence in jurisdictions abroad. But all this has to be disclosed now in the income tax return.
All right, Mr. Singh, this is clearly a very explosive issue, and one is expecting that there will be several developments from all the enforcement agencies, also from the stakeholders who are clearly up in arms and who are defending themselves. So clearly admissibility of evidence, usage of treaties, and of course, eventually the most important thing, which is to sift the legitimate entities from the illegitimate entities. That, of course, will be something that will be closely watched by several regulatory agencies, not only in India, but across the globe. On that note, let me now thank all the three guests, Mr. Kanambar, Mr. Rohan Shah and Mr. B.M. Singh, for joining me for this special show, The Panama Files.
Find us on Facebook at facebook.com/ETNow and don't forget to click the like button. You can also follow us on Twitter at ETNowLive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/ETNow.